Hey there, business owners. Welcome back to our channel where we break down the complex world of debt collection. Today, I'm diving into the crucial topic of legal theories and causes of action in New York debt collection. Hello, and thanks for joining us today. My name is Jocelyn Nager, the managing partner of Frank Goldstein and Nager. In this segment, we will discuss legal theories and causes of action in New York debt collection. This video is for informational purposes only and is not intended as legal advice. If a demand for payment has failed and you're thinking about going legal, this video is for you. So, what exactly is a cause of action? Picture this. You've got a mountain of unpaid invoices and you're ready to take legal action. Based upon the specific facts of your case and your specific industry, your New York debt collection attorney will now need to decide the appropriate causes of action so that you can prove and win your case. These causes of action are essentially the building blocks of your complaint to be filed with the court. They set forth the facts that support your legal right to collect the money owed to you. But how does she choose which causes of action to include? As mentioned, the decision is determined by the underlying facts and specific industry. Let's explore some common causes of action. The first and most popular in debt collection is a breach of contract. This one's pretty straightforward. To succeed, you must show that a valid contract existed, the customer requested services, you performed those services as agreed, and the customer failed to pay. That does not necessarily mean that if you do not have a written contract, you can't proceed. There is a cause of action to cover when a written signed contract does not exist. That is a quasi-contract. Imagine you run a remediation service. You're called in for emergency water mitigation. The customer signs a work authorization. You and your crew perform the job. You bill the client, and then nothing. The customer doesn't pay. Here you've got a solid breach of contract claim. Another possible cause of action is for an account stated. This cause of action comes into play when you send an invoice or statement demanding payment, and the customer doesn't object. Silence can sometimes be golden, especially in debt collection. The lack of objection can imply acceptance of the debt. Now let's talk about unjust enrichment. This is a versatile cause of action that doesn't necessarily require a written contract. The idea is that the customer or a third party has benefited from your service and it's unjust for them not to pay. For example, if an insurance company pays the insured directly for your work and the customer pockets the check instead of paying you, in addition to benefiting from the work they hadn't paid for, the client insured benefits from the insurance payment. A classic case of unjust enrichment. Another real-life example helps illustrate how the underlying facts and your specific industry help to determine which legal theories or causes of action to include when going legal. Consider a rice importer with a signed contract to sell rice. The client places an order to be delivered in the future at an agreed price. As nearing the delivery date, but before shipment, the market price drops and the buyer cancels the order, buying cheaper rice elsewhere. Here, the importer can sue for breach of contract if they suffered loss or damage as a result of the contract. The rice importer will need to do more than show a breach of contract, as they will need to show the court why they lost money for goods they never shipped. Causes of action for a simple breach of contract and account stated in this example would not best fit this situation. By including multiple causes of action, you increase your chances of winning your case. It's like having multiple shots on goal. Your goal is to draft your legal papers for mediation, arbitration, or litigation so that the creditor can prevail in its claims and so that the court clerk can enter a default judgment without the necessity of a court order. So there you have it, folks. Understanding legal theories and causes of action and significantly boost your debt collection success in New York. If you have found this information helpful and want to learn, please like and subscribe for additional videos and to our weekly blog, which offers tips to collect. Please check our website for updates on New York debt collection, updates on laws impacting debt collection, and some case studies. If you would like to contact us, you can reach me at jnager@ffgnesqs.com and by phone 212-686-0100, extension 12. Frank Goldstein and Nager. We have the experience that pays.